Hello, it's Philip Taylor speaking from Richmond Green Chambers in London. It's my privilege to review this book by the late Derek Roebuck, whom I knew. It's been edited by his widow Susanna Hoe. It's the last book that Derek wrote. Obviously it's been put together in his memory. It's called More Disputes and Differences, Essays on the History of Arbitration and its Continuing Relevance. It's come to us from the Arbitration Press and HOLO books, and I've given it a very simple title for the review, a fine tribute to Derek, because that's the way I feel about this book. Let's have a look at it first of all. There's the front. You can probably see the picture. It says automatic arbitration. Now that's an old photograph of a drawing, but it's the same problem today, and that is we're getting automatic arbitration. There's the spine and there's the back. There's quite a lot on the back, and I've used part of that in the review. Opening the book up, you've got a nice picture of Derek and his wife there, Susanna, and some blurb. And then on the back of the dust sheet, you've got some of the previous publications, because Derek's actually written a lot of important books as I see them over the years. They've been extremely helpful in terms of arbitration. Now what we've got is a standard index at the back, which is quite up to date with some of the stuff. For instance, you've got online dispute resolution, you see mentioned even now, and you see how things have changed. The index is actually by page number, and it's quite a substantial index, quite helpful. The book runs to under 400, 370 pages, something like that. Now there's the front page, and there's some of the previous books that Derek has written. Then there is actually a nice little dedication. Elizabeth and I do not review books which are we consider pretty useless. This one isn't. It's an important book. The reason we actually review these books is because we like them, and this is one of Derek's last volumes, and his work is obviously, as they say, they've been continued. There are a lot of people who are involved in supporting the publication. Then you've got the various parts of the index, part 1, part 2, and then part 3, and then you lead into a preface which sets out, and there is of course a lot of extensive footnoting which is useful. But you've got the preface then, which Susanna wrote in August of this year. I'm recording this in the autumn. Then you've got acknowledgements, and then after that an introduction from Susanna, and then the main book. We're starting off with part 1, the past, and obviously going on from there. And you can see the structure of the book. There's a quote going back a bit, and of course the book runs through on that basis. There's a lot of footnoting. It's a learned book, and it's an important one, and it's very much part of that library of books which Derek Roebuck created, and which it's his legacy, and we are actually, I think, very grateful to have them. I do believe ADR is very much misunderstood. It's also misapplied as well, I'm afraid to say, because there are a lot of cases I have where there's absolutely no way that the guys are ever going to arbitrate. Any form of ADR is just, it's not worth it, because they're not going to agree. But that's the problem of the type of work I do as counsel, where I've got two implacably opposed parties, and even getting them to mediate is going to be basically not going to happen. The thing is, we do try that process, and I think you have to try it, but I have to be a realist about how far I can take people. I've always said to them in mediation that what you do, you can take a horse to water, but you can't make it drink if it doesn't want to, and I'm afraid that's the problem. However, this book, as with the series, gives us a wonderful idea of the span historically of how arbitration itself and dispute resolution is actually viewed. And I think that's a wonderful statement, both of the history and to a certain extent where we are at the moment with the attempts, and it's a cynical attempt, frankly, by governments to shove everything to mediation, when in fact they know that a lot of people, the only thing that's going to happen is they have to present their case in court and a decision has to be made and they either win or lose. It's as simple, in my view, as that. And I think if you start complicating it, all it does, it costs a lot more money, and it doesn't make for good law at the end of the day, and it actually doesn't really help the rule of law either. But that's perhaps a personal view. So what do I say about the book? Because in some ways Derek's book, More Disputes and Differences, is a work in progress, because he had a rule that where possible he would suggest what research needed to be done. So that's why we had things like ADR, Alternative Dispute Resolution, in business, topics for research in 2012. However, whatever one's view, as I've said, about ADR, it's here to stay, although less convinced practitioners may dispute the concept. I've certainly seen that. I don't dispute it, I just think it's got to be, perhaps we've got to view it in a slightly different way as the century rolls on. Now, the book is edited here by Susanna Hoe, Derek's widow, and she has added into it articles, lectures and chapters dating from Derek's 2010 volume, Disputes and Differences, which originally were brought together. But whereas the chapters of the earlier work that he produced was a thematic work, as she calls it, this book, particularly the two contents in part 1 and part 2, in part 1 specifically, which is about the past, brings together the history of arbitration and mediation from prehistory to the early 19th century. And it's got actually a long and distinguished history. What makes this volume, I think, particularly interesting to us is that it's possible, chapter by chapter, to conclude which of Derek's multi-volume histories he was working on at the time and what other works he was reading or hearing then. And I think that's an interesting pointer. It's fairly well illustrated in the last essay in part 1, which is called A Pinch of Reality, Private Dispute Resolution in 18th Century England. That was in 2019. And then we go into part 2, which is the Past, Present and Future, which again was worked on initially in 2013, and it began with the Future of Arbitration, and then it ends with Keeping an Eye on Fundamentals in 2012. And then in part 3, the last part, we've got Language, Research and Comparison. The collection features commentaries, of course, here, that bow to the author's particular interests. I'm using the words that they've used here, and their connection to arbitration and its history. And I've always believed, in terms of teaching law and trying to understand law, that you have to look at the historic situation. You have to look at the way that the law is developing at a particular time. Now, I'm an older guy. I can remember very substantial changes in the early part of 1970, with the changes from assizes to the Crown Court, and the huge changes that were beginning and have taken place since. Massive case law, massive statute law, codification. So history has to play a role, and it's the same with arbitration. As I've said, unfortunately, this is the last volume that we will have, which was worked by Derek. It was not quite completed before he passed away, and so obviously Susanna has stepped into the breach and produced this particular book, and we're very grateful to her for doing it. I think one of the final points I'd like to make is that the final chapter, Return to That Other Country, Legal History and Comparative Law, 2019, one of the last pieces that he wrote, and it says it all, because we'll miss Derek's tremendous range of knowledge in what will continue to be a developing area of dispute resolution. But we do have his books, and for that, and for us, the memory of his undoubted learning, I think, and his erudite wisdom contained in what he's left behind for us will be there. So thank you to Derek, and thank you to Susanna for this last tribute. Now, the date of publication of the book is the 5th of November 2022. Let's just have one last look at it. There it is. As I said, I repeat, I do like the front, because we are at the moment in a business where it's automatic arbitration. It's automatic this and that and the other. But you and I and everybody else really knows It's not quite like that, but there we are. Now, what I did like, for instance, you've got some really very substantial detail. I'm right in the middle of the book here, looking at Italian arbitrators in Elizabethan London. That is not this Elizabethan, it's the other one. And it talks about people like Phillip, for instance, and quite a lot of other people are mentioned. Other Italians are mentioned. This is in the 16th century, of course. Then you've got conclusions at the end. So it always follows through a nice little structure, and there are some really very useful points, and I think I'll just highlight again. Again, there's one thing I did think was quite important. ADR in business, topics for research. That, I think, again, is probably something that we will want to start having a think about in the future, because the law is moving. There are new generations of people coming up as barristers and solicitors. There are new values in Parliament and a new approach, especially with new technology, with all of the dreadful things that brings and the tremendously important things that it also brings. So we have to look at it, but the basic principles are always there, and that is, if you can try to get a dispute resolved without having to go to law with the pomposity of the wig and all the other stuff that we have to do. It's there for a reason, I'm defending it, but at the same time, if we can ease it off the other way, when you have a success with mediation, it's great, but unfortunately they don't always succeed. On that note, thank you to Derek and thank you to Susanna. Bye-bye.